All right, moving on. So, what about the principal's duties to the agent? So, if a contract exists between the agent and the principal, then the principal simply has a duty to comply with the contractual terms. So, if there isn't a contract, and let's say the agent is an employee of the principal, then additionally, the principal has occupational duties to the agent. So this would be the duty not to impair the agent's performance, the general duty of care to the agent, a duty to disclose known risks, also the duty to provide reasonable, safe working conditions. And there is no fiduciary duty that the principal owes to the agent. And if you remember, a fiduciary duty simply means that an agent is tasked with the responsibility to respect the finances and business decisions and business implications of a principal, which is what a fiduciary duty entails. It's a sense of responsibility. The principal does not owe the agent that. So the principal doesn't need to worry about if the agent is, let's say, their own finances or their things. It's a one-way street between the principal and the agent. So what happens if a agent goes and does something for a principal and it wasn't authorized under actual or apparent authority, but then later, once the principal is made aware of the purported agent's action in which the agent acted on behalf of that principal, what if they ratify it, which means that they accept that? If this occurs, then the law assumes that there was an agency relationship, and they apply that back as if there was a authority in the first place, even though there wasn't in the initial, like in the beginning. Is the principal's ratification would essentially authorize an unauthorized act. And then this would then have the legal effect of actually satisfying the agency relationship, and specifically the authority required for the agency relationship. So ratification is a voluntary election to treat as authorized an unauthorized act or contract purportedly done or entered into on the principal's behalf. So it's important to note also that notice to a third party is not needed for ratification, and ratification or the question of it only comes up if the initial act by the agent was unauthorized. So if it was authorized to begin with, we don't even care about ratification. So for ratification to satisfy or essentially authorize an unauthorized act, then the principal must be aware of all material facts when assenting to the agent's act, and much in the same way that actual authority, where it can be express or implied. Same with ratification. This may also be express or implied. And once it happens, it just happens. It's all or nothing, and it's irrevocable. So let's look at this example. So Tony contracted to purchase 500 pounds of fish from Greg on behalf of Teresa. Teresa did not know Tony or Greg and was unaware of the transaction. When the fish arrived, Teresa accepted the shipment. Her ratification of the transaction may be inferred. So here you have Tony, who goes and buys fish from Greg, and he does so for Teresa. But Teresa didn't know that Tony was going to do that, didn't know Greg at all, was unaware that Tony went and did that. But when the fish actually came and Teresa took the fish, then it's a ratification of Tony's transaction. And in this case, the law would assume that an agency relationship existed both during, before, and after, essentially, due to Teresa's ratification. So keep this in mind. If actual and apparent authority or doesn't exist, it could still create an agency relationship if the principal ratifies that unauthorized act. And remember, the act, while unauthorized, had to be done by the agent on the principal's behalf. Just all the other elements of agency have to be there as well when it pertains to the transaction. So next, let's look at a concept called vicarious liability. So vicarious liability essentially is when the actions of an agent can actually hold the principal liable if the agent acted in either a tortious, so commits a tort, or performs something, or which is a bad act that could incur liability while within the scope of employment. So let's dive deeper into this. Let's read the example, and then we'll go back and look at the elements. Okay. So Mary hires John, a real estate broker, as an independent contractor to market her 15-year-old home. John told Michelle, so a third party, that the home was only 5 years old. Michelle bought the home. Both Mary and John are liable for any harm suffered by Michelle as a result of the fraudulent misrepresentation. Moreover, Mary is entitled to be indemnified by John if she must pay damages to Michelle for John's misrepresentation. So let's break this down. You have Mary and John. So Mary is the principal here, and she hires John as her agent to act on her behalf. She has intent. She authorizes John to go do so because she hired him. The home is only 15 years old. John essentially misrepresents to a buyer that the home is actually 5 years old, and Michelle relies on it. So therefore, the misrepresentation plus reliance, if you remember, becomes a fraudulent misrepresentation. This is a form of fraud. So because John was Mary's agent and he essentially committed a tort of misrepresentation, anything that comes from that misrepresentation on the part of Michelle, would then go and actually make Mary liable, simply because John was operating as an agent for Mary at the time that he committed the tort. So it's very simple. It's almost like a parent and a child. It's like a parent is held responsible for the child's act. In this case, it's not a parent and a child. It's a principal and an agent. So the agent then has to be performing this act, right, within the scope of employment. So the vicarious liability can extend to the employer when the employee commits a tort, whether negligently or intentionally, was not authorized by the principal to perform the act, or performs the act within the scope of employment. So when the act of the agent or employee that results in harm occurs, if it's a tort, then the employer or the principal is liable immediately. If the employee does something and the principal didn't authorize it, the principal can also be liable for that. And then lastly, if the act was within the scope of employment, then we look to see if the work that the employee was doing was it assigned by the employer, or was it a course of conduct that the employer controlled? So this would be an example of, let's say, I'm hiring a delivery service van, and the delivery service van injures somebody while delivering food on my behalf. That would be work assigned by me, so it would fall within the scope of employment. Or let's say it's a delivery van, and I had a look to see what the employee was doing while delivering for me. That would be conduct subject to the employer's control. If the employee then hurt somebody while driving that van, I'll be liable to that hurt person. So an act is not within the scope of employment if it's an independent course of conduct not intended by the employee to serve a purpose for the employer. So think of that example where I hire a delivery van, and the delivery van, while driving, my agent hurt somebody, is if he was driving to deliver my products to someone underneath the scope of employment and it hurt somebody, then I would be liable. But if he decided to park the car, go and deviate from his work and go grab pizza somewhere, and he hurt somebody while he's getting pizza, then I wouldn't be liable because he did his bad act not within the scope of employment. And hopefully that helps. So lastly, how is an agency relationship terminated? So much like the way a contract is discharged or terminated, it can happen either through mutual consent of the parties or through the operation of law. And these are very synonymous with the contract doctrines that we looked at regarding contract termination or discharge. So an agency is based on the mutual consent of the parties. Thus, it may be terminated at will by either party or both, even if the termination breaches a contract between principal and agent. A principal may revoke a grant of authority at any time. And keep in mind, if one party breaches the contract and says, hey, I don't want to be your agent anymore, then it still counts as a contractual breach in which the principal can sue the agent for damages, but it ends the agency immediately. The agency must have the mutual consent of the parties in order to go forward. And then lastly, we'll look at when an agency relationship is terminated by operation of law. So very similar to the contractual doctrines, this happens when there's illegality of duties to be performed by an agent, or if the agent or principal dies or is incapacitated. And there's certain situations in which the incapacity or the agency relationship still exists in an incapacity due to the power of attorney on the previous slide. All right, thank you.